My name is Weng and my metric number is BB22110602. So the first issue is whether the first bank reasonably rejected the documentation supplied by Capital Machinery Ldt under the letter of credit LC in view of discrepancies. So the documentation required include a clean bill of lading, commercial invoice, 100% value goods insurance certificates, and certificates of conformity issued by Plant Inspection Service Australia (PISA). So the discrepancies include the first one is a different agency signed certificate of conformity. The second is 90% not 100% insurance covers. Then the third is documents present out of 15-day period of times. The rule used in this case is the doctrine of strict compliance governs letter of credits, requiring that documents submitted strictly conform to the terms specific in the LC. This principle is codified in the Uniform Custom and Practice for Documentary Securities (UCP 600). So the first article is Article 2 of UCP 600 defines a complying presentations as one that meets all the credit terms. Then the second is Article 14A, state that banks must only examine the face of documents to determine compliance. So third is the Article 16C, allow the banks to reject documents that fail to meet LC requirement or are submitted after the specific time frame. Applying this principle to the facts of this case, first, bank's rejection of the documents was justified. First, the certificate of conformity was issued by the different certificate agency instead of PISA, as explicitly required by the LC. This division directly related the LC terms and is comparable to the ruling in JH Rania, where discrepancies in document terminology warrant rejections. Second, the insurance certificate provided by Capital Machinery Ldt cover only 90% of the goods value instead of required 100%. This partial coverage, which the LC terms as full insurance, is critical to ensure complete risk coverage during transit. This situation is analogous to equitable trust, where even minor departure from compliance were deemed unacceptable. Finally, the documents were submitted beyond the 15-day periods specific in the LC. Under the Article 16C of UCP 600, banks are permitted to reject documents present after the stipulated time, consistent with the principle in C Consa, where delay or omission result in non-conformity. To conclude, first bank legally refused to honor documents in that Capital Machinery Ldt could not be applied such stringent requirements under UCP 600 for compliance. The case law confirmed that no deviations, regardless of their perceived significance, are permissible in context of LC.
So for issue 2, the issue is whether Capital Machinery Limited breached its FOB contractual obligations by causing delays in export clearance, which in turn delays shipment. So under FOB terms, the seller must deliver goods onto the buyer's vessel and ensure timely export clearance and meet agreed shipment timelines. For supported case law, the first is Mitchell Courts and Company Middle East Limited versus Hair Co Limited in 1943. The court found that sellers' export clearance delays constitute a breach. The second case is Peter Turnbull and Company Proprietary Limited versus Manders Trading Company Australia Proprietary Limited in 1954. The court stressed that under FOB agreement, failure to deliver on time allows repudiation. And the last case is Pyrene and Company Limited versus India Navigation Company Limited in 1954. The court clarified that risk and property transfer after loading if obligations are fulfilled. For application to this case, Capital Machinery Limited failed to meet the agreed shipment deadline. There was delay caused by their negligence in export clearance procedures, and comparable to Mitchell Courts case, where seller caused export delays were deemed a breach. In conclusion, Capital Machinery Limited are likely breached FOB obligations by failing to clear goods timely, and Jaya Construction is entitled to reject goods and repudiate the contract.
The issue 3 is whether Jaya Construction's Liam Berhad JC was justified in refusing to accept the goods due to First Bank's rejection of the document and the alleged late shipment. Under UCP 600, strict compliance with the terms of the letter of credit is mandatory, as outlined in Article 14C and 16C. The letter of credit must be adhered to precisely, or the insuring bank is entitled to reject the documents. In FOB contract, sellers are required to load the goods onto the buyer's nominate vessel within the agreed time frame. Failure to meet this obligation constitutes a breach of contract. The legal principles in this case are supported by two important cases. First is in United City Merchant vs. Royal Bank of Canada in 1983. The court held that buyers can reject goods if the document failed to comply with the letter of credit terms, regardless of the goods' actual condition. The second is in Peter Turnbull vs. Manders Trading Co. in 1954. The court emphasized the seller obligation under FOB contract to ensure goods are shipped on time. In this case, First Bank rejected the document due to their non-compliance with letter of credit terms. JC relied on this rejection to justify its refusal to accept the goods. Additionally, JC alleged late shipment by the seller. If it can be proven that Capital Machinery failed to clear or load the goods on time, this would further justify JC's rejection under FOB terms, based on the principle established in Peter Turnbull. To conclude, JC's rejection of the goods was legally justified due to the non-compliance of the letter of credit document with UCP 600 requirements, while the alleged late shipment required further evidence. It would reinforce JC's position under international trade law.
Greetings, Doctor. So I'll continue to discuss issue 4, whether First Bank's refusal to honor the letter of credit was justified despite what Capital Machinery Limited claimed were minor discrepancies. So let's begin with the key issue. First Bank rejected the documents presented by Capital Machinery Limited due to, firstly, the certificate of conformity being issued by a different agency than the specified, and then insurance coverage only being 90% of the goods value instead of 100%. Lastly, the documents being submitted beyond the letter of credit's 15-day period and validity. So for the main legal principle here is the doctrine of strict compliance under the UCP 600 framework. Article 2 defines a complying presentation as one that strictly conforms to the terms of the credit. And then under Article 14A, banks are required to examine only the face of the documents to determine compliance, while Article 16C allows rejection if the documents are presented after the credit's validity. These principles ensure the integrity of the LC process and maintain trust between all parties involved. Now, let's analyze the legal grounds for First Bank's rejection. First, case law supports the strict compliance principle. In Equitable Trust, Core vs. Dawson Partners, 1927, the court held that even minor deviations justified rejection. Similarly, in J.H. Rayner and Core vs. Ambrose Bank, 1943, discrepancies in terms, even if immaterial to the trade, invalidated the presentation. Finally, C. Concert Far East Limited vs. Bank Makaze, 1993, reinforced that timeliness is critical under Article 16C, and even slight timing deviations render documents invalid. And then applying these cases as well as the rules to the current situation, the wrong certifying agency undermines the buyer's reliance on LC terms as seen in J.H. Rayner, as well as Article 2. And then the 90% insurance coverage fails to provide full risk protection, violating the LC's terms as per Equitable Trust Article 14A. And then the late submission of documents breaches Article 16C and aligns with the C Council presented. So, in conclusion, while Capital Machinery Limited argued that the discrepancies were minor, these deviations were material under the strict compliance doctrine. Thus, First Bank's rejection was legally justified under UCP 600 and supported by case law. Thank you.